Excellent. Well, it looks like we're underway. Thank you and welcome to this webinar. I might just check, Anne, will you be doing the welcome for us today?
I'd like to welcome everybody here to the BFSLA seminar on War in Europe, Sanctions Re-examined. We've got a fantastic panel here today. We have Aaron Wolfson from KWM in New York. We have Sarah Salmon-Elliott from Minter Ellison Rudd Watts in Auckland, and Ursula Mccormack from KWM in, I think, Sydney. Is it Sarah? Ursula? So it's obviously a highly topical topic that we have for this webinar. So I'd like to now throw to Ursula, who's going to chair the session and who will also do Welcome to Country.
Thank you very much, Anne, and welcome all. Just before we kick off, I might just ask Sarah and Aaron just to briefly introduce yourselves and then we'll kick off. I'll hand to you, Sarah, first.
Thanks so much, Ursula. Hi, everyone. Good morning, good afternoon, and good evening. My name is Sarah Salmon. I'm a corporate partner at Minter Ellison Rudd Watts in Auckland, New Zealand. I specialise in public, regulatory and international trade law, with quite a healthy portion of my practice being sanctions related, and in the last 6 weeks, quite a healthy portion of that being Russia sanctions related. Aaron.
Good afternoon, everyone, or good morning. My name is Aaron Wolfson. I am a partner at Kennywood Mallisons in New York, and I have an extensive background in economic sanctions. I was a prosecutor in the United States for about 10 years, and I spent 4 years almost exclusively doing sanctions prosecutions. We prosecuted a number of large global financial institutions for sanctions violations as they related to Iran and other countries. And thereafter, I worked in sanctions at a large global financial institution and have been a practitioner in this space now, in private practice for, about 7 or 8 years. So, as Sarah said, the last few weeks have shown a lot of new sanctions that have come into play, and there are a lot of questions out there, and so I'm privileged to be here with my colleagues and to spend some time with you all in talking about some of these new sanctions.
Thanks very much, Aaron and Sarah. My name is Ursula Mccormack. I'm a partner of Kennywood Mallisons based in Hong Kong and Sydney. My area of focus has been on regulation and data regulation, financial regulation and financial crime for many years, but largely based in Asia. So I will cover off the Australian sanctions piece today, but I also want to share a little bit about how we're looking at it in a number of other markets as well. I have the great privilege of being your moderator today, and I'm going to make this a very discursive session, because I know a lot of people here who are on the webinar have a good understanding of a lot of the basics. There's a lot that's been out in the press, and we really want to drill down into some of the really practical questions and issues that are facing banks and other financial institutions to kind of bring this issue to life. Now, for those of us in Australia, I would like to formally begin by acknowledging the traditional owners and custodians of the many lands from which we meet today across this ancient continent now called Australia. We recognise their continuing connection to land, to waters and to community. We acknowledge and pay our respects to their elders, past, present and emerging. I'd also like to pay our respects to any First Nations people with us today, together with all of our valued guests and presenters. Now, without further ado, I'm going to hand over to Aaron to kick us off with the US side of things. Over to you, Aaron.
Thank you. Thanks, Ursula. And good morning again, everybody. Good afternoon. I'm really privileged to be here with you all. So the last, we're now April, well, it's April 11th here, it's April 12th there in the future where you guys are. The last going on almost 2 months now, but we'll call it 7 weeks now. I think has seen the largest, the most expansive set of sanctions that we've seen in such a short period of time, right? If we think back historically, the Iran sanctions, really ramped up, over a number of years, and these Russian sanctions, while there were some sanctions in place in 2014 and some additional ones over the years thereafter, the kind of sanctions that we've seen since kind of the middle of February are really like nothing that we've seen before in terms of scope and kind of impact on daily business, as Russia was is a huge part of the global economy. And so what areas are we going to look at? So today we're going to talk about regional sanctions, right? The prohibitions on U.S. persons engaging in transactions in certain areas, individual and entity sanctions. So sanctions that have been placed against key individuals in the Russia and Belarusian governments, oligarchs, media outlets, and others. The kind of financial sanctions or large-scale sanctions against the Russian financial system, and there have been broad prohibitions on financial institutions and financial instruments. We've seen additional energy sector sanctions, right? A lot of sanctions against the petrochemical industry. We'll talk a little about some of the latest developments and what's left or what's next and what else we could potentially see happen. We'll go on the next slide. And, so for these comprehensive regional sanctions that OFAC and the U.S. government have put into place, U.S. persons are prohibited from exporting or re-exporting or selling, directly or indirectly, goods or services or anything to the Donetsk and the Luhansk regions, right? And so these sanctions, as it relates to those regions, are very similar to the sanctions that we saw or continue to see today in the Crimea after the annexation in 2014. Now, the question is U.S. person, and U.S. person is an interesting definition, and we really need to look at each of the sanctions programs to understand what that encompasses. But for the most part, U.S. persons are U.S. citizens or lawful permanent residents or those who hold a green card. Any entity organized under U.S. laws, including its non-U.S. branches, as well as anybody who is physically located in the United States, right? And for many of you all, one of the things that you want to think about and kind of keep front of mind when you think about U.S. sanctions is, okay, do I have any U.S. persons? Do I have any U.S. citizens who work in our bank? Do we have any U.S. green card holders who work in our institution? Because you want to make sure that those folks are if there's anything that might have to do with a U.S. sanction, that those folks are walled off and have no part in that. What else has happened? There were some general licenses issued when these sanctions came in place for a brief wind down period. Those wind down periods have kind of ended now. And so the sanctions really are starting to take effect. We'll go on to the next slide, please. So, we have seen a number of individuals and entities that have been sanctioned as a result of, their association with the Russian invasion of Ukraine, and we've seen, high-level members of the Russian government sanctioned. We've seen, Vladimir Putin sanctioned, the Minister of Foreign Affairs sanctioned, the President of Belarus themselves sanctioned. So that means any of these folks, any of their assets, anywhere in the world, if U.S. persons come into contact with them, they're required to block those sanctions, right? There have been sanctions against Russian media outlets, their executives, their owners, key employees, a number of sanctions on Russian oligarchs, right? And as well as Belarusian officials. So, for a bank, again, and for an institution, if you are looking and you're working in this space. If you have Russian clients or Russian affiliates, you want to make sure that none of those folks are subject to sanctions and are on the SDN list. And these sanctions have come out kind of over a course of the past several weeks, right? And they're kind of coming out on a rolling basis. We'll go to the next slide. So, there have been additional sanctions, of individuals who are associated with abuse of Russian civil rights advocates and whistleblowers, blocking sanctions on entities that have been known to evade sanctions, right? Blocking sanctions on defense and technology firms and institutions in Russia, and sanctions on the dark net market and the virtual currency exchange market. So, the U.S. is really, the sanctions are meant, there's a threat to national security of the United States and its foreign policy goals, and these sanctions are meant, to impact, virtually every part of, of the Russian economy, and that's the rationale behind it. We go to the next slide. There have been, some kind of unprecedented maneuvers as it relates to financial sector sanctions as well. And the U.S. has imposed a wide range, an unprecedented range of sanctions on the Russian financial sector. There are some blocking sanctions. There's our prohibitions on U.S. financial institutions from participating in the primary or secondary market for ruble or non-ruble denominated bonds, right? There are prohibitions to access to correspondent and payable through accounts for certain entities. These include Sberbank and its subsidiaries, right? There are prohibitions on prohibiting U.S. persons from dealing in new debt and new equity of certain Russian SOEs, financial institutions, and others. There are prohibitions on dealing with the Russian central bank. SWIFT, has taken the kind of almost unprecedented step at this point, right? And removed a number of banks from the SWIFT messaging system. And when you remove a bank from the SWIFT messaging system, you are really hampering that bank's ability to be able to engage in communications with other financial institutions and move money. And there have been additional restrictions for financing and capital markets access, right? So, but it's so all of these sanctions have kind of meant to hurt the to impose that U.S. persons can't do anything. And when we say U.S. persons, nobody can cause a U.S. person to violate these sanctions, because one of the things that the U.S. sanctions regime has done very effectively over the years is to either prosecute, both civilly and criminally, those actors that cause violations of U.S. sanctions. That means a party outside the United States that is trying to do something through the United States can be held liable for that. Go on to the next slide. The energy sector sanctions. This is kind of an area that there's been a lot of activity in. There's been a little bit of restraint shown in sanctioning the Russian energy sector to prevent some damage to European allies that rely heavily on Russian energy, right? But the U.S. has designated the Nord Stream 2 as an SDN. There's been a ban on the U.S. import of all Russian origin oil, petroleum, natural gas, and coal products. There's been a prohibition on any new U.S. investment in the Russian energy sector. So there's been a lot of movement, against the Russian energy sector. Go on to the next slide. We can go to the next slide. So the executive branch actions have continued, and the U.S. Congress has passed legislation just, I believe it was last week, stripping Russia of most favored nation trading status and banning the import of certain Russian goods, right? And so this is going to have a large impact, I would think, on the trade relations between the U.S. and Russia. There have been a number, the executive orders that have come out have prohibited U.S. persons from any new investments in Russia. OFAC has the ability to prohibit U.S. persons from engaging in any categories of services if it so chooses. Congress has voted to remove, like I said, the normal trade relations for Russia and Belarus. They voted to ban the import of Russian oil, natural gas, and coal. And the recent sanctions on Sberbank and Alpha Bank have been upgraded to the full blocking sanctions. We go to the next one. So, there are some things. What is there left to do, right? Well, despite these actions and the unprecedented coordination with the U.S. and its allies, the recent Russia and Belarus sanctions are not fully comprehensive, and there does remain some room to continue to escalate, right? As you see here, energy transaction payments are somewhat on limits. You can have sanctions on additional oligarchs who there are some the U.S. has not yet sanctioned. The U.S. has not employed secondary sanctions yet. And I think those secondary sanctions could have major global implications if they were put into play. So there still are additional sanctions tools in the U.S. arsenal if they want to use that they have not used yet. We go to the next slide. I'll just add here that there have been additional recent U.S. import and export controls on Russia and Belarus, right? There's been, they're expanded, and I'll just touch very briefly on the export control piece, but there's are expanded license requirements, right? There are new foreign direct product rules. There are entity list and military end user expansions, right? There are restrictions on luxury goods, right? There are restrictions on the imports of seafood, alcoholic beverages, and diamonds, right? The export of U.S. denominated banknotes. So, the U.S. is approaching these sanctions with both, the notion of OFAC and the Treasury Department, but also, the Commerce Department and export control sanctions, as well as economic sanctions. We go to the next slide. So what we've seen here, right, is a coordinated enforcement effort. We've seen, the U.S. and its allies in Europe and in Asia, have been really coordinating almost to an unprecedented degree on this. Luxury items have been red flagged, right? We've all seen in the news how yachts are being seized. I read today that somewhere there are 100 airplanes of oligarchs sitting on a runway, right? And I think we're going to see more OFAC enforcement as it relates to this, and then we'll end with just some kind of compliance, just some kind of simple compliance thoughts here. We'll go to the next. So, in terms of the coordinated efforts, right, we've seen Australia, Canada, the EU, France, Germany, Italy, Japan, the UK and the US all kind of working together, right? And all kind of, sanctions have been announced, kind of together, right? There have been, the US has launched a number of task forces, right? The Department of Justice has launched a task force, klepto capture. The Treasury Department has launched a kleptocracy asset recovery rewards programs. And, when typically and historically, when the Department of Justice and the Treasury Department have launched these type of programs, they're looking at enforcement. They're looking to find targets of that and seize assets. And the Department of Justice has already done that with regards to its task force, and they just made a big joint announcement last week on some indictments and some seizures. So I think that what we can expect to see is a level of coordination amongst the U.S. and its allies. And we can also expect to see, a large, I think we're going to see a lot of enforcement for sanctions evaders or for these folks who are SDNs over the next few years. We go to the next slide. And I would just add one thing, while this is happening now, it does take a while for the U.S. government to bring sanctions cases, right? And so I think that we're going to see, enforcement of these regulations for years to come. So one of the things that we've seen FinCEN, the Financial Crimes Enforcement Network of the Department of the Treasury. They've issued an alert on reporting suspicious transactions in real estate, luxury goods, and other high value assets of sanctioned Russian elites, right? And, they've taken the unprecedented step of, when financial institutions file their SARs, which are confidential and nobody outside, a couple people in the financial institution will know they're filed with the Treasury Department. They've taken the step to indicate, that it's related to Russia on the SAR. So, in addition to having the U.S. the government on the lookout for these things, the Treasury Department, the Justice Department, the financial institutions are being urged by the Treasury Department to keep a keen eye out for this stuff and to kind of flag them if they see it, right? And they're looking at real estate, artwork, precious metals, luxury yachts, aircraft, and the like. Go to the next slide. And this is just, historically we've seen OFAC, the past couple of years, they average maybe 20 or so cases a year, and I think that we will see some additional enforcement, as early as in the next few months, and definitely continuing over the next several years, even as it relates to these new sanctions programs. We'll go to the next one. And in the U.S., right? Sanctions, we have what we call a strict liability regime, right? So that means that a violation is a violation is a violation, right? You don't need an intent requirement for OFAC violations. Even where you conduct due diligence, violations can occur. Due diligence isn't a complete defense, but look, we all know, I think having an effective compliance program in place is key for avoiding committing violations, which is number one, and for mitigating penalties when the violations occur, right? So, while OFAC is strict liability, it's important to have all these things in place and to know who you're dealing with for mitigation. Go to the next slide. And, as we talk about sanctions and kind of, goes without saying, right? Senior management commitment and tone from the top is critical. Understanding your risk, especially with these new Russian sanctions, understanding what your exposure is, in your sanctions risk assessment. That I'm sure in the past 6 weeks everybody's had to kind of tear up their old risk assessment and kind of start again, right? And I would say training is critical in this space, right? Training really is kind of one of the most important things, so that your folks can learn what is and is not prohibited. So I hope that was a helpful kind of overview on where we are today, and I'll pass it off to Sarah now, and then happy to take some questions later on. Thank you.
And Sarah, just before you begin, thanks very much, Aaron. I just encourage anyone to please feel free to post any questions in the question Q&A function. We've had a question already, which I'll come back to, but just for Aaron and Sarah's awareness, it relates to the IP that's held and sought to be protected in Russia, and in particular, whether or not we're seeing permit holders being able to obtain sanctions permits to receive payments in relation to their permits, or to indeed make payments, and alternatively just abandoning their payments. And perhaps we can come back to this question both from the subject matter of IP, but perhaps more broadly as well. So Sarah, over to you.
Thanks so much, Ursula, and to Aaron. I should say at the outset, there appears to be a mandatory shutdown happening on my computer. So I have my IT team here, so hopefully I get through my presentation without a hitch. What I want to do, I'm going to talk for 10 to 15 minutes. I'm primarily going to focus on developments in New Zealand regarding Russia sanctions, but I think it's really helpful to understand the extent to which New Zealand's sanctions regime has actually evolved in the last 6 to 7 weeks. And the only way to do that really is to start by giving you a very quick introduction to our wider sanctions regime, just so you can see just how much has changed. Next slide, please, Matt. So like all UN members, New Zealand has to implement UN sanctions via the UN Act and the Terrorism Suppression Act. We have individual regulations relating to each of the different UN programs which set out the relevant restrictions on imports and exports, commercial dealings, asset freeze requirements and travel bans, etc. A couple of interesting points about the UN sanctions regime in New Zealand. It has relatively limited extraterritorial reach, so it applies to New Zealanders wherever located, New Zealand corporations, everyone located in New Zealand, branches of New Zealand corporates offshore, and New Zealand flagged vessels. But unlike the US regime, for example, it doesn't always apply to the overseas located subsidiaries of New Zealand companies or to transactions involving US dollars or New Zealand dollars or New Zealand origin goods. The offence provisions are broadly drafted, so essentially any kind of involvement in a sanctions breach in New Zealand could be deemed an offence. The maximum penalties have not changed since 1990, so many of you would consider them sort of a somewhat slap over the wrist with a wet bus ticket. Maximum penalties there for an individual, 12 months in prison or a $10,000 fine, or maximum penalty for an infringement for a corporate of $100,000. I think it's important as part of our compare and contrast piece to underline that there has been historically very limited administrative resource given to sanctions, administration, compliance and enforcement in New Zealand. So our Ministry of Foreign Affairs and Trade does all the policy development, goes to the UN meetings, has set up the business registration system in the past when we've needed that for Iran, but there was one person in legal division with that responsibility. We have customs officials who monitor sanctions compliance at the border, but this is not a particular enforcement priority for them. And then the New Zealand Police Financial Intelligence Unit, they receive suspicious transaction reports relating to our AML-CFT regime, but they've done very little traditionally with regards to sanctions enforcement. There's been very little enforcement action in New Zealand, and we've had one prosecution, which was a case I worked on involving Pacific Aerospace, and we've had one civil case. So all of this to say, up until very recently, we had quite a light touch sanctions regime in New Zealand. The top issues for banks and financial institutions with that regime predominantly related to the Iranian market and predominantly related to New Zealand companies and particularly banks being very concerned about complying with the extraterritorial aspects of the US sanctions regime on Iran in particular. And we've had a spate recently of Iranian customers of New Zealand banks complaining about discriminatory treatment because they've refused to process transactions with an Iranian nexus. And there's been a lot of complaints to the Human Rights Commission, which have primarily been settled through mediation discussions. Next slide, please, Matt. So over the years, particularly in the last 10, 12 years, New Zealand has been under a lot of pressure to create an autonomous sanctions regime. There has been nothing until earlier this year. New Zealand was able to introduce unilateral sanctions type measures in the past, and it had done so earlier this year in relation to Russia. So a number of travel bans were imposed on Russian politicians and Security Council members. We had export controls imposed to prevent New Zealanders from exporting military equipment to help the Russian war effort. And we also suspended certain diplomatic ties with Russia, but they were relatively light touch sanctions measures. Over the last 10, 12 years, New Zealand's Five Eyes security partners and Western allies have put New Zealand under quite a lot of pressure to pass autonomous sanctions legislation. And also the Conservative opposition in New Zealand has twice tried to stand up autonomous sanctions bills to create an autonomous sanctions regime. And the ruling Labour Party has always said, look, you know, we feel that the UN system works well. We don't actually think that we need this autonomous sanctions regime. And that all changed in February of this year with the creation of New Zealand's Russia sanctions regime. Next slide, please, Matt. So on the 8th of March, the New Zealand Parliament passed the Russia Sanctions Act. It did that under urgency in one sitting with full unanimous support of the House. And what this act does is it gives the government the power to make regulations to designate classes of persons, assets and services to be subject to sanctions. The actual individual names of those persons will be set out in designation notices. The regulations also outline the specific prohibitions and restrictions that are going to apply to dealings with designated persons. So we have varying ranges of restrictions applied to different categories of designated persons, from travel bans, transport bans, preventing aircraft and boats from coming into New Zealand, asset freezes, and restrictions on dealings with the assets and services of designated persons. And a departure from what the UN sanctions regime looked like, this new Russia sanctions regime also creates new obligations for duty holders. So duty holders under the AML-CFT Act, so largely this is going to capture banks, financial institutions, casinos, etc. So it obliges duty holders to freeze the assets of designated persons that come into their possession or control, and it requires duty holders to make reports, excuse me, when within 3 days of becoming aware that they're holding the assets of a designated person. Another interesting observation here is we've now seen a tenfold increase in the maximum financial penalties for a sanctions breach in New Zealand if it relates to a breach of Russia sanctions. So now we're looking for individuals at an imprisonment term of up to 5 years or a $100,000 fine, and for companies a fine of up to $1 million. There has been a significant bolstering of the government staff put in to support the creation of this Russia sanctions regime. At the top level, there is very strong ministerial oversight of the regime's development. So the Prime Minister and the Foreign Minister are taking the lead, but there is actually 8 government ministers taking an active interest in the development of New Zealand's Russia sanctions program. There is a team of 105 individuals at the Ministry of Foreign Affairs and Trade working in the Russia Sanctions Task Force. And if you compare that at the beginning of the year to the one sanctions desk officer administering the UN regime, you can see that really New Zealand has taken this very seriously and stood up a regime in very quick order. It's really unclear at this stage, 6 to 7 weeks in, what the enforcement approach is going to look like. But what we do know is where there was once one person administering and monitoring compliance from an MFAT perspective, we now have 105. So we expect that there will be a much more of a focus on enforcement under the Russia sanctions regime than there was under the UN regime. Next slide, please. So then on the 18th of March, the government made the Russia sanctions regulations. This is the first set of regulations made under the Act, and we had the first tranche of designations made by way of designation notices. So this very much focused on political and military personnel, members of the Duma, members of the Russian Security Council, 18 military organisations and 1 military connected bank. The second tranche of sanctions came in on the 4th of April, and this very much targeted a small group of Russian oligarchs and their close family members. I think a couple of interesting points to note about the regulation is that when compared with the UN regime, New Zealand has, this goes much further, the extraterritorial reaches farther. So these sanctions will apply to anyone who's, in inverted commas, carrying on business in New Zealand, which is actually going to capture quite a number of foreign organisations who would otherwise not find themselves subject to UN sanctions in New Zealand. Sanctions will also extend to the associates of designated persons. And interestingly, when you compare it to the 50% rule of jurisdictions like the States, New Zealand has a relatively low 25% rule. So you can be an associate of a designated person if you are their agent, if you are owned or controlled 25% or more by them, or if you're a senior manager operating for a designated person. There's also a number of really interesting exceptions set out in the regulations, Regulation 12. Some of these have been put in to now allow New Zealand businesses to wind down their business with Russia, others to enable Russian citizens in New Zealand, of which there are 15,000, to keep their personal bank accounts open. But also there's been a couple of interesting exceptions put in there for corporates that are owned by people who will probably become designated in the future, and the provisions have clearly been put in there to help those corporates to keep operating. There are more regulations to come. So on the 25th of April, we will see another set of regulations. We haven't seen the draft yet come into force. They're going to impose this 25% tariff on imports from Russia, which many Western governments have imposed in the last few weeks, and also extend export prohibitions to cover strategic industrial products that might be of benefit to Russian strategic industries. I think one of the most interesting things that we and our clients are watching closely is that ministers are currently considering a proposal to designate further Russian banks. At the moment, it's solely PSB, which is designated, and that's a bank which not many New Zealand corporates have anything to do with. I think as soon as we see the likes of Sherbank and VTB designated, that's going to create all sorts of difficulties. So just finally touching on, given this regime, what are the top issues that New Zealand banks and financial institutions are facing at the moment? Well, resourcing is a major issue. As I said, the New Zealand government has stood up this Russia sanctions regime in the space of 6 or 7 weeks, and it wasn't anticipated that this would happen. So a number of the banks in particular simply don't have the resources and staffing necessary to do this enormous amount of DD that's required, particularly on a huge volume of incoming payments from Russia. Outreach is also a problem because, traditionally speaking, the banks haven't had to do much with the Ministry of Foreign Affairs and Trade, and the Ministry of Foreign Affairs and Trade is drafting the sanctions regulations. So they don't actually have established relationships with each other. And this is leading probably to bad regulation drafting, but we're hoping that those relationships will strengthen in the weeks and months ahead. There is an enormous backlog of payments that the banks are holding on to from Russian banks, predominantly banks that have been designated by other jurisdictions, and New Zealand is just unsure, gosh, if this bank, this payment that came via this Russian bank and that bank is designated by the US, by Australia, it's a US dollar payment. There's an enormous amount of confusion within the banks as to what can they process, what can't they process. So we have a big backlog of payments and quite a number of disgruntled customers waiting on money. There's a number of New Zealand corporates who are trying to wind down business in Russia and having difficulties with that, whether they have factory presence on the ground or assets up in Russia, and the banks are involved in assisting with those discussions. And finally, a number of New Zealand banks and financial institutions have investments in Russian securities or other financial instruments, and they'd already announced to the market that they would exit. And then the Russian capital controls came in place, and it actually became quite difficult to do so from a practical point of view. Now it's become more practically possible to divest. It's becoming a bit more tricky to divest from a legal perspective. So that's really a sort of summary of the key issues we're seeing at the moment. Next slide, please, Matt. These are just some resources for any of you who want to read more. A couple of the links to the key government pages, which are relevant for those with an interest in sanctions, and also if you're interested in any of the particular regulations that have been passed so far, what might be coming down the track, etc. I've just included some links to some articles we've been writing recently, so you're very welcome to read those and get in touch, of course. And I'm very much looking forward to your questions.
Thanks very much, Sarah. And just as we pass on and move on, I wanted to ask you both just that question around patents in Russia, this business that's carried on, existing business and existing rights that can only be enforced through transactions with Russia. What are you both seeing? Sarah, perhaps you first, and then Aaron. You're on mute.
Sorry, Ursula. I think I just got interrupted then, but I think you said your question was about patents and IP rights protection up in Russia.
That's correct. So the question that came through in the Q&A was specifically about patent holders whether or not they're being granted any permits to enable payments to Rospatent through the Russian central bank payment system, or are foreign companies abandoning patent protection in Russia? Now, I don't expect either of you to be IP experts, but just generally on the topic of those sort of rights to be enforced, in relation to Russia, all those commercial interests, are we seeing them abandoned? Are we seeing them, pursued through permit arrangements?
Yeah, that's a good question, and hopefully our IP partner sits right behind me, so I have a fair sense of what's going on. What we're seeing is a number of New Zealand corporates do have IP protection up in Russia, and their regular payments are coming due for those. The payments are being stopped. But the payments are sometimes, from a clearly non-designated person coming via a non-designated bank, and there's a lot of nasty emails going back and forth with the people in Russia wanting money, people in New Zealand saying, well, the banks have stopped the money, and the general approach, I think, is with the smaller value payments. We're just putting our hands up here saying, I'm sorry, it can't be done. And we'll just say, we are asking for creative solutions of how we pay, but at the moment it's becoming very difficult to pay. And I think for many companies, it makes sense to abandon IP protection because they're no longer going to be sending the related products to Russia anymore anyway.
Thanks, Sarah. Aaron, did you want to add anything?
Yeah. I kind of ended up by saying I'm not an IP expert, but I do know, that in the past few weeks, I think at some point in March, the U.S. Patent and Trademark Office kind of discontinued any relationship with Russia. And look, any payment to be made out of Russia right now, any payment that anybody look at Russia out of a Russian bank, you need to look at the sanctions, right, and to see what is permissible under the sanctions, what hasn't been sanctioned, and if I would have to check on the intellectual property, but I don't think that they're included in any kind of general license that's currently in place, because most of those general licenses in place are for humanitarian reasons. So if this is one of your concerns about trademark, I'd look and patent and trademark, look at the sanctions, look to see where it covers off on that piece, and my sense is it's not going to be a prescribed area, and you're going to have to get a specific license to make those payments through if any designated parties are involved.
Yeah, thank you both very much. And I think one of the key things is like reading the contracts, right? And it seems such an easy thing to say, but often we're seeing wildly different, sanctions provisions, force majeure provisions, termination rights, and even just, asserting rights, even if you're not able to, take payment, for example, in a given scenario, but making sure that that right is not yet abandoned. There's a few kind of things to know, things to kind of map out, right? Okay, brilliant. Okay, I'm going to come back to some of these topics in a moment. Let me just whiz through for you the Australian regime and just some of the other key markets to know. So if I can ask the team to just put up this slide, we've deliberately kept it quite short. So the key things to know here is that Australia, like New Zealand, like many other jurisdictions, has implemented not only the United Nations sanctions regime, but also an autonomous regime. Now, what has changed in particular is that we have, from the end of 2021, a specific piece of legislation that empowers the designation of entities and individuals, and not just countries. So we've had sanctions that have related to the former Federal Republic of Yugoslavia, to Myanmar, to Syria, Zimbabwe, and indeed Russia and Crimea for quite some time. But we now have these 6 prohibitions that are administered by the Department of Foreign Affairs and Trade. They cover different individuals, entities, goods, services for each jurisdiction, and indeed bodies corporate can also be deemed to breach a prohibition if they have effective control of the actions of another body corporate, and that body corporate engages in prohibited conduct. I raise that because we've got a lot of financial services people on the line, and a lot of you are working for organisations that may well have interests in other companies as well. And these 6 areas are very specifically defined within the legislation, and there is both the Act, the Autonomous Sanctions Act, there's the regulations that spell out a lot of the detail, but there's also designations which now supplement that and really need to be read together. Now, one thing I did really want to call out here, so we've got making a sanctioned import, making a sanctioned supply, certain commercial activities, But the key ones, I think, for financial services entities that are so important are, in particular, providing a sanctioned service. And depending on the sanction that applies, this can be read very broadly. It can include technical advice, assistance or training. It can include financial assistance, so funding, credit. It can also cover a range of financial services, and that specific term is defined very broadly: an investment service, a service providing financial advice, brokerage, insurance, reinsurance, derivatives. So that kind of scope is probably the greatest risk that banks face. It's also the case, I'm sure, not only in Australia, but far beyond, that banks are considered to really be the gatekeepers to prevent sanctions breaches. So you are banking a number of customers or providing other services to a number of customers. And often I find in our practice, the greatest risk is where it's in the high value or the resources space, where those particular customers are not themselves regulated for diligence. In the banking world, we've got correspondent banking controls that enable people to piggyback off the compliance regimes, generally speaking, to create a system that is considered to be safer perhaps than it might otherwise be. But it gets particularly thorny with the sorts of services that Aaron and Sarah were talking about, those high value asset services, real estate, luxury goods, and even just the oil and gas and other resources sector, where it becomes especially thorny for financial services entities. So just remain mindful that the financial services industry is a really big target. And some of the key areas of focus from regulators globally is not just who you fund and the specific breach of a particular sanction, but also what controls you have in place. So really strong focus on controls. Now, in terms of when these prohibitions apply, it can apply to conduct that occurs wholly or partially within Australia. It can also occur in relation to conduct that occurs wholly outside of Australia, but by an Australian person or entity. So remember, as is the case in the US and in other markets as well, that you may well be the nexus for a sanctions breach. It can also, thirdly, cover conduct that occurs wholly outside of Australia by a foreign person or entity, where the result of the conduct occurs in Australia, which could well be just simply a payment, and the conduct is an offence in the country in which it occurs. So that sort of jurisdictional nexus is deliberately very broad. Thankfully, in Australia, however, there is a due diligence regime which really assists financial institutions to demonstrate they did everything that was possible. Things that form part of the enforcement policy in other markets are sort of more enshrined within the regime itself. I think the others have adequately covered what has changed over time, but just I think the key thing to know there is that Australia is largely tracking the flow of designations and sanctions in other markets, and that includes interests in Russia, the certain regions of Ukraine, as well as Belarus. If we move to the next slide, I wanted to briefly touch upon some things that we see in other markets. So the market that I probably know best, having spent there many, many years, is places like Hong Kong that only apply the United Nations sanctions framework and not autonomous sanctions at all. So with Russia as a member of the United Nations Security Council, at least for the time being, I know there's many rumblings about that, there won't be a UN sanction on Russia absent some sort of significant upheaval. So what we then look at in those markets is not to say, well, look, anything to do with Russia is fine. We're then looking at the undercurrent. What is the actual substance of the sanction that might apply elsewhere, or else connected with that individual transaction? So a lot of the Russian sanctions originally related to bribery and corruption and kleptocracy, right? So those came with Magnitsky developments. We have a regime in Hong Kong that relates to bribery, corruptions and proceeds of that sort of activity. We also have a regime that relates to WMD non-proliferation. The trickier parts of compliance in places like Hong Kong is the question of when you may be circumventing sanctions abroad and then bring yourself into the mix of those offshore sanctions. We also have jurisdictions that are like New Zealand, are taking a sort of, let's say, a unique break from the traditional UN approach, with this. And in Singapore is a case in point. So it specifically imposed export controls and blocking of certain financial transactions connected to Russian banks and financial institutions just last month. The second point I wanted to make here is that for jurisdictions that are not applying anything at all that say formally today, there are some things to bear in mind. So China, India, obvious examples. And you'll see a lot of speculation in the press over whether some of these countries may be subject to sanctions themselves for not imposing sanctions. So we've heard rumblings from Biden and China. We've seen the White House security advisor alluding to G7 countries having a united response to make sure Russia can't evade sanctions through other countries. But it is difficult to comment generically because we are starting to see some entities in those markets perhaps take a more cautious approach or take a different approach than in other markets. So just last week, we saw a large petrochemical and gas project on pause, and others considering their own sort of nexus points, perhaps also mapping who they have on their books who may need to be taken off deals. And then finally, we also see the challenge of voluntary requests made to industry. So the UK Maritime Authority first asked for help with controls in relation to Russian controlled vessels before it actually became mandatory. And that's something that we're saying companies need to grapple with, where they're trying to comply with a voluntary, non-mandatory requirement. In terms of the industries to watch, high value assets, definitely number one, resources number two, area I cover and know very well, the crypto industry has at the start seemed to not be seen as quite high risk, and some announcements from FinCEN along those lines, but we're now starting to see much heavier controls on that industry. The EU, for example, announcing that high value crypto asset services should not be made to Russian accounts. So that's the synopsis, a really fast breeze around those other markets. And now I want to come back to just the discussion with our team here. And I've seen a number of questions come through as well. And the first one I'm going to raise, we've got a question that says, remitting refunds for goods and services already contracted to Russian customers has become problematic since the US dollar and euro were restricted from remitting to any persons within Russia. The banks don't provide any clarity either. What are your thoughts? Aaron, I see you smile. I'll give this one to you first.
No, I mean, look, this is what happens with sanctions, right? I mean, sanctions are imposed. There's a wind down period. Generally, that wind down period it runs out, and absent applying for a specific license from OFAC, and getting that license granted, and that's a long process, right? You're not going to be able to do it. You're not going to be able, you're not going to be able to get, your money back. And the banks don't provide any clarity either. The banks, that's the comment, right? Look, the banks are struggling with this as well, right? I mean, they're figuring this all out at the same time everyone that you all are as well. So they don't have the clarity, and the U.S. banks are going to take a very conservative point of view and approach to the OFAC sanctions, and they're not if they don't think that something is permissible, they're not going to do it.
And Aaron and Sarah, just in the last couple of minutes, so on things like court, so we've got another question around court debt collection, are we in a similar position here from your perspective?
So I'm willing to take that one. Certainly in the New Zealand regime, there's no specific provisions relating to court debt collection. The key issue is going to be whether the Russian entity is a designated person or is owned or controlled by a designated person, or the agent of or senior manager of a designated person. So it's the identity of the Russian entity that will be the issue, rather than any specific rules we may have on court debt collection.
And in the U.S., look, you can bring litigation on the debt collection. There are generally provisions in most of the sanctions programs that allow to represent sanctioned parties in court. And, you can see what, we can see what the courts would say about it.
If I could, Ursula, also just give one piece of advice to Dan on the payments issue. I mean, even if you have a payment that's not subject to sanctions, we're finding banks all over the world with huge backlogs of payments that they need to assess and either decline or process. And some banks, more than others, Societe Generale, for example, has an enormous backlog. But as Aaron said, the issue is they just, they've got this huge backlog. They don't necessarily have the expertise in order to be satisfied with the DD that they've done to clear them. But what we're finding can be helpful is if you actually supply the DD to the bank to help expedite their work. And the benefits of doing that is that you potentially get your payment process before the rules change, and potentially a payment that's lawful today becomes restricted next week.
Thank you. And I'm going to pose to you sort of a final question as we wrap. And the question is, what is the biggest pain point that you're seeing for banks and financial institutions? And what is the way in which you see an efficient way to resolve it? So we make this rapid fire. Aaron, I'm going to pick on you.
Understanding your customer base, understanding, what, who owns what. A lot of Russian structures and Russian company ownership is opaque in nature, and making sure that you fully understand who the beneficial owners are and kind of sifting through the layers of ownership.
I love that one, Aaron. I think we see that even outside financial institutions, just not knowing, right? And getting that information, customers, transactions, vessels, where are they going? Where your exposure is, what citizenship your staff have, right? Yeah.
The uncertainty.
Yeah. Sarah.
I see the number one issue for New Zealand banks being resourcing. So we have certain bank clients who have sort of a frontline sanctions team of 2, and they've got 30 live job advertisements. So there's a real lack of staff and brain power necessary to process the new rules, and also the payment backlog. So certainly resourcing is the biggest issue so far.
Amazing. Thank you both so much. And I'm going to quickly pass back over to the BFSLA team to close us off. For my part, thank you so much for joining, both of you, with me and all the participants as well.
Well, on behalf of the BFSLA, I'd like to thank our panellists very warmly today for their very valuable insights and an extensive, quick overview of all the key issues that are confronting our financial institutions and banks at the moment. It's been a terrific session, and I'd just like to thank you very much from the BFSLA's point of view. I'd also like to take a moment to spruik our annual conference, which is running on the 26th of August. Because of COVID, it's going to be run both in Sydney and Auckland at the same time. So hopefully we'll be able to see everyone in person in Sydney or in Auckland. So thank you once again for the terrific session and for the very valuable insights that have been provided today. Thank you.